now you can't just see waiting for some a person to return when the other is waiting. So the talk you can move on.
1676 or 2019. Ana sa escuela acabando.
Morara, Kebaso, Morara, Kebaso.
Please record. Amakatarua. For the Morara Kebaso together between and Amalo. Honorable Jeremiah Kiani. After Bashir, Bianca Maina, the Waititu. Oh, sorry, I forgot that we are reading manual. Asha Bashir, Bianca Maina, Hiro, Eric, Euli, Mareno, Solomba, Nordin, Kakai, Willis, Otieno. I hope I have introduced all those that are present. There are more. There is Bishop Edungo.
Present, Your Honor.
Getahi Quincy. Getahi is not present. Who else is present and I have not introduced?
Yes, Oringe Waswa.
Patrick Navin.
Present.
Michael Wanyama. Omboko Charles. Kyoko Mwende. Anybody else have left out? Yvonne Akini. We are ready to take the book.
So you are the one reading the thing?
Yes, I am ready.
So will everyone be speaking? Or
if I leave something out, but if I don't, you will appreciate the nature of the case. You know,
okay.
I would not want to down.
I wish we had more space. Habari yako? Unaitwa nani?
Maybe move a little so that he is properly visible. Thank you.
language do you prefer?
Your Honor, on behalf of the prosecution, since there's,
Yes.
together with my Ondimu, together with my colleague Ms. Naika, Ms. Kerubo, Mr. Kirago, and Ms. Njoroge.
I've not yet seen. Before we hit the clip, I'm going to ask all of you to just aside. Leading that gentleman. Please just step back so that the give it his space. Yes,
Honorable signatory and afraid that you have not been brought before you. Yet you did the business.
Your Honor, there are two different files. Once we are done with this, definitely will be produced. I don't know why I think they're in the same file. I'd indicated to him there are two different files.
Morara, Kebaso, Kenya. These are your charges. Your charge is cyber harassment, contract section 37 of computer misuse and cyber crimes, Act number 5 of 2018. Dated on the 28th day of September 2024 at Ferninard place within the Republic of Kenya. Make sure you let us know before court while using export account dumped at Morara, Kebaso, Kenya, you knowingly, without lawful excuse, posted false information to which I quote, William RUTO approached DL Langat and told him he desperately needs more money for campaign. DL Langat used his property as security and took big loans to help his friend. Right now, DL Langat is being auctioned by banks, and the person who is buying the property is William RUTO. To make it worse, William RUTO has used his powers to undervalue the property to buy them at a cheaper price. That is the kind of a person we are dealing with. He has no friend. Contact whose information you knew to be false and calculated to punish and discredit the reputation of one David Langat. Is it so not?
Before he pleads, it looks like there's a mismatch in the charge sheet, and that it may not be worthy of pleading to us. So we'll be asking him to reject it under 89. If you look at the charge sheet and the particulars, if at all any name was to be tarnished, probably it would be that of William RUTO, if the particulars were not true. It would not be the name of David Langat. So what is the fear of putting the name of William RUTO as the complainant? This is a very, and you can see, I don't know how it has been drafted, but if there was a name to be tarnished here, the person who is looking like ungrateful and not quite a friend would be William RUTO. So I'm urging the court to read the charge carefully and reject it, because it doesn't, something is not adding up in this charge sheet. Even if we go to trial on this, and even if David Langat comes, it will not be sufficient without William Ruto as the complainant.
Yes, Your Honor. Just to be precise on what you answer. Yes, just to be precise on what the senior counsel submitted on. There is no doubt that the particulars of a charge sheet must be able to inform the accused person what he or she is pleading to. And that the particulars of an offense as and that the particulars must speak to the alleged offense. They must clearly square out the subject of the complaint to which our client has been brought to you to plead is one Mr. William Ruto. And therefore, if the offense as drafted would have any meaning in law, to the extent that our client is able to respond either positively or negatively, the particulars must relate to the subject. To that extent, Your Honor, this charge is defective, it's not what the paper is written on, and our client is not able to leave it as the particulars do not inform on how he should leave. It does not disclose who is the complainant. Is the complainant Mr. William Ruto or is it P.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's for you.
Your Honor, if I may.
Yes,
Your Honor, if I may, the church is brought before you this afternoon, Ashabati.
and I see that we don't take a lot of time on this.
Yes, I'm only raising one
Just
issue.
request that we don't take this for the other
Yes,
person.
yes. I'm only raising one issue,
Mm.
that the alleged complainant here is also not a witness. I'm wondering how the two police officers will be the witnesses in this matter. Yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you.
Your Honor, I will make a very short statement.
Yes, Tom.
I'm really sincere. An accused
Yes,
person
Tom.
an accused person under 50.
Yes, Mr.
Under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceeds to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Lagat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Lagat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before Your Honor
Mr. Ochieng,
yes.
we don't know that there could be reporting this one with blood pressure. So you need just to check on your voice so that you can
I'll be something like the bottom. I know sometimes I sting like a bee. The bottom of my own. I'm not eject. So, Your Honor, that's all I know. The particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's disconnect in the two. So will Mr. Morara be required to respond to the count of cyber harassment or the particulars of defamation? That charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, civil division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to this set free forthwith, unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
Very, very kind commission. Just a moment. If I write everything, if I say the wrong thing,
That's what justice serves. That's what it means.
that's the challenge with us lawyers. We respond to what we don't know. We don't know what I'm going to say. So I'll be writing manually because we have not set up the gadgets. We didn't know this case of this kind of coming today. So now just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. So we'll have them transcripted.
It's a very kind commission in the matter is a Manyora, and I wish to grant the court's statement. I'll pick it up from where my learned senior Mr. left it, and urge us to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. That is under Article 25C of the Constitution. Very quickly, Your Honor, I will, with ability, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be informed of the charge with sufficient detail to answer it. But, Your Honor, what has come out in the few minutes before, Your Honor, 50 Article 2B. Your Honor, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J. 52A all through to 50Q, Your Honor, is what constitutes fair trial. Such that, Your Honor, we stand before you this morning or afternoon, the accused person is clearly not able to understand, Your Honor, what is responding to. This is a provision, Your Honor, or this is a right, Your Honor, which cannot be limited. I invite court to find basis on those two articles, Your Honor, to reject the charge that have been read out. That's all from me.
Yes, Your Honor, I just wanted to say one or two things. Yes, Your Honor, my name is Eric Fury. Your Honor, you've been referred to articles to refresh what has been stated. But Your Honor, so that you are not told that this court jurisdiction and the discretion under section 89 of the CPC
decline these charges, if you are of the opinion, and Your Honor, we persuade you to be of this opinion, that the charge sheet before you does not insufficient material disclose a case to enable the accused person to take a plea. Your Honor, I'll finally say, and I think I have said this before, if we continue at this rate, we will have to seriously expand this course. Because, Your Honor, what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country. Sometimes, yes, I can say something that can be offensive, but does that constitute a crime? It's the danger that we face with this kind of practice. Your Honor, for those reasons, and being that these courts are temples of justice, this court has recognized, and the High Court, I think, has recognized the manner in which of late police have been conducting their arrests by way of abduction of those people. We may not be able to stop the police in the manner in which they are behaving. But there must be a place where they know that they can play their little games outside there with the lives of each and every one of us, because it basically means that no one is safe. I can make a statement that it is deemed criminal. Let them know that those games will not be entertained within the corridors of justice. And so, Your Honor, I plead with this court that we must take all the circumstances of this case, and the circumstances of this case then explain the paucity in the charge sheet as has been presented before.
No, I think you have an emergency of 1 year. And it's important that the court directs on this.
Should we call for a short adjournment so that the court is clear and the person has there? They need a short adjournment.
There are some other rooms on the other side that are bigger and more. No, this is the biggest. Wampeleke the other side.
Thank you. Your Honor, it is the last time we appeared in the court over this matter. The court had to buy me microphone. I was avoiding that because I don't want it to go on record. But it looks like, I mean, at a certain point, we may really need to think about fasting and whatever. The manner that we are. But Your Honor, what I was saying is that the circumstances of the arrest and then demonstrate why. Yes, Your Honor. Yes, Your Honor. So my final point is that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest, and it will be able to understand that the intention here is for this court to be a conveyor. We abducted him, we were unable to. So, Your Honor, what I was saying is that this court is then intended to be a conveyor. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is finished. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is fair, and then even this court will eventually almost be on trial the way our police are on trial. You know, for that reason, I'm noting that Mr. Morara had a young counsel that he had instructed. So I ask that you allow Mr. Semonka to just say one more thing, and then I know all of us would want to say something. But I recognize that we also need to write ruling on this. Well, I'm being reminded it's also a
Please, Your Honor, my name is Marema. I humbly and wholly appreciate the recognition in my land of seniors, computer and mission and cyber crime act. However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer Mission and Cyber Crime Act. Specifically section 22 of the Computer Mission. If you go on further on, they repeated the statement, false, again. And then lastly finished with calculated to tarnish the calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or civil or defamation? Your Honor, in brief, as I associated both my learned senior Counsel Eric Theory stated, I was with Morara when he was being arrested. The police refused to grant me access to Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. Your Honor, the question is, we are dealing with people.
Sorry. We might all of us end up fainting here. So please, just a request that you allow me to manage the crowd. But request everybody after the gentleman in the big camera. We are just going to ask you kindly to step out of the room. Otherwise, we can't face the Please, you can listen from outside. We have speakers. So we have speakers. So now, if your problem is that, you just have to break. Because help comes first. Please. They want to see you cancel speaking.
Oh, yes, Your Honor. So,
because you can get, so many of us are sweating. You can get the smell of sweat. Very soon it all comes.
Yes, Your Honor, I'll be brief. Your Honor,
How many more minutes will you take?
3 4 minutes.
Okay, please.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take plea.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young person. To release, to free him from discharge. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, Your Honor. Fellow Gen Z. And we will stand with him.
May the court afford exactly 1.5 minutes. My name is Achille Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, there's a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 20 that obligates this court to adopt 20 sabbatical 3A. Now, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional application, and when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on these issues, is about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy, alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds. Only one about the charge sheet, because it will become relevant for them in response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. That the charge sheet itself is indicating erroneous dates when our client was arrested. We say that they arrested him today. And the fact is that they arrested him yesterday. They have a duty to disclose all the material facts, and there is a reason why the